4 reasons you are going to want to stick around for this session. 1, it's not about TCPA, and we promise it's not about TCPA. 2, you have no plausible deniability, you're here, so you should stick around. 3, one of our speakers is a former detective that worked homicide. He will find you if you don't attend. And 4, if the legal jokes and the threats and the fear don't work, Matt and Zora have promised that everyone that sticks around gets a free cocktail. If you ask a question, you get 2 cocktails. All right, big picture here. Why compliance? Why this afternoon? Why an afternoon session, right? So first, for us, this is cultural. If you've read anything we've put out in the last several years, 7 years, right, we believe in the golden rule of data, right? Treat other people's data the way you would want your own data treated, the way you would want your child or your parents' data treated. We also believe in the corollary to the golden rule of data, which is the businesses that have the best compliant and governance on that data will win in the long run. And so we are betting on that differentiation. Second, I don't need to tell you that consumer compliance is shifting so fast beneath our feet. You saw a lot of stats earlier today. You've heard almost everyone touch on it in some way. So this session's really about zooming out. And for those of you that have never been into the gallery, when it opens in about an hour, what I will say is zoom out. Aside from the amount of art that you're going to see, and aside from the sheer volume and numbers, one of the single biggest differentiators about this collection and anything else in the world is the way that it is designed on the walls, the way that it is laid out room by room. It is unlike any museum or collection you will see in the world, not for its volume, but for its zooming out display. And what we're going to do this afternoon is zoom out on compliance. We're going to talk big picture, not TSR, not DNC, but how you turn compliance into a strategy and into a muscle memory. And those in the back, you can keep moving forward. Thank you. Okay, so cutting right to it here, right? Let's just get our speakers ready to go, and they are coming up. Okay, so I'm going to introduce 2 badass compliance executives, and I get to call them that. So Deborah Solmor handles legal, regulatory, and compliance matters at TCS, a nonprofit system of 6 colleges, universities that seek to advance student success and community impact. Maybe more importantly, Deb founded a program called Ready, Set, GC, which helps women who are new to the GC role navigate the challenges and unique aspects of that role. You might find Deb enjoying a yoga session, spending time with her new puppy, Remy Martin, getting away to the Colorado mountains, or at a Dead & Co. or Billy String show this summer. Terance Gonzalez is a partner at Alston & Bird LLP Litigation and Trial Practice Group. He also chairs their education team. Maybe more important, Terry was a former police officer and detective while going to law school, and he did work homicide, assault, robbery, and more. His favorite assignment may have been working a plainclothes as tactical officer dressed as a gang member. You can find Terry biking, boating, surfing, and paddleboarding or vacationing in Mexico. But even more important, he recently tried and won a certified class action in Los Angeles. Winning was his only option because Deb was his client. So with that, I will give you the stage and the mics. Thank you very much.
Okay. Never been told I need a mic before, but
That one's live now. Okay.
okay. All right, cue the music.
That play button. Big green button.
All right.
All right, good afternoon, everybody. Thank you for sticking around to listen to a couple of lawyers chat about compliance. You are brave. Rob said that they saved the best for last, and that's why we were put here. I think he was referring to the cocktail reception, not necessarily us. But it's a pleasure to be here. It's a pleasure to see everybody in person and be back at these conferences. And Matt and Eli and everybody, thank you for the invitation to speak again. We are going to talk about compliance and talk about compliance in the marketing space. And so, Deb, why don't you tell us why it is that this is an important topic for us to talk about?
Sure. And again, thank you for finding us appealing, I think the term was. So we appreciate that you all sat around and found us appealing as opposed to all the other people who left. But in any event, so why are we here? So we've listened to some really, really great presentations all day long. And I think what we're here to do is to either, if you don't have a compliance organization or a compliance function in your business, I'm here to say, I hope when you leave here, you'll be scratching your head saying, wow, this is really something I should be looking at. If you do have a compliance organization, I'm hoping that you see it as a necessary good and not a necessary evil. So if you don't see it as a necessary good, that is my sort of takeaway for you. If you have a compliance organization and you already see it as a necessary good, I would have two things to say to you. First, hopefully we're going to kind of give you some guidance at the end about what you can do next for your compliance organization. Or I would ask that you go out there in the back and get the two of us a cocktail because you probably don't need to be sitting through our presentation. So again, we're going to help you figure out how compliance can be a necessary good in your organization.
So for those of you in the audience, how many of your companies actually have a compliance function in the company? Okay. And for those of you in the audience who do have a compliance function, how many of you interact with them and work with them collaboratively? Okay, that's great. All right, Deb, what is compliance? What is ethics?
Great question. So usually you'll often hear compliance and ethics put together. Read together. This is our code of compliance and ethics. This is our compliance and ethics team. So are the words the same or are they different? They're different, right? So compliance is following the law, complying with laws, and ethics is really doing the right thing because it's the right thing to do. So today, most of what we're going to be focused on is really in the compliance space, but we'll kind of touch on the ethics space as well. And so as we're going to kind of moderate back and forth, Terry, why don't we talk a little bit about some examples? What does that mean? It's kind of nice for me to give you all the definition, but in practice, what does that mean?
So when I think of the difference between compliance and ethics, and to use a very simple example would be, the law may allow you to reach out to your consumers 6 times, 8 times a day. And you would be compliant if you did so, and you wouldn't be violating the law. But the question is, should you? Is that the sort of interaction you want to have with your consumer base? So when I think of, ethics, I think of course, Spike Lee, do the right thing. What would you like to have done with yourself and with your consumers? So, why is this important, Deb?
So, I know some people, having been a chief compliance officer in a publicly traded company for several years before my current GC role, so I've done the law thing, I've done the head of the legal department, I've been the head of litigation, I've been the chief compliance officer. And believe it or not, I have been accused, and my team has been accused, to be the place where good ideas go to die, where fun never happens, and then there's the no police. Right, so one year for the holidays, I bought everyone on my compliance team a different coffee mug that had sort of one of these like bad compliance jokes. I think we saw one at the beginning, "Don't make me use my compliance voice." It's important because it really does great things for your business. First and foremost, it really sets the tone for your organization. It tells both your internal and your external stakeholders, so your employees, your management, your board, and then externally, your customers, your regulators, that complying with the law is important to you. It really helps buy goodwill, it increases your brand reputation, and it sets a roadmap for your employees. I don't know how many of your organizations have sort of that fundamental code of conduct, but when you bring on new employees, they read your code of conduct, they know that they're at a place where compliance matters and doing the right thing matters. So I think it's got a lot of really, really great attributes that have nothing to do with the actual work of a compliance team.
So what do you tell your clients when they say, well, I have good insurance policies, I make sure I get indemnity in all my third-party contracts, so why do I have to invest further time and money and resources into a compliance function?
Well, first I scratch my head. And I think that is a very common belief, that those are ways that you can sort of substitute around a true compliance program. So I would say for both of those, Insurance, indemnity, and contracts, they're one piece of risk mitigation, but they really are not a substitute for sort of a full-on organizational compliance program. So with insurance, I would say, what does your insurance policy, how many of you here know you have insurance for your organization, right? Show of hands, I'm sure most of you. How many of you have actually read your insurance policies? If I ask you, do you know what's excluded from your policy? Do you know what's covered in your policy? Most people will say I have insurance, but they have no idea what it covers and what it doesn't cover. And then the other thing is, as a perfect example that I just went through not that long ago in my organization, is we had a lawsuit filed against us, and some of the claims in the lawsuit kind of allegedly fell within the insurance coverage, but many of them did not. So where my client thought, oh, we got insurance for this, no problem, the insurance carrier said, well, you have insurance for this piece, but 80% of the lawsuit we're not going to cover. You pay for that on your own. So I think it's really understanding insurance. And I will turn the mic over to you and say, what about indemnity? Everybody says, oh, I have contractual indemnity. I don't need a compliance program.
Yeah, so I think the issue with indemnity is similar to that with insurance, which is what does the indemnity actually cover? So the first thing you're going to do if you've received a claim and you think it should be indemnified by a third party is, what's that language actually say as to what conduct is covered and what conduct is not covered? But I think probably more importantly is who's providing the indemnity, and does that company have the financial wherewithal to actually pay if they have to? And if they had to pay, will they? Are they going to be a good partner? I can tell you a horror story of an audit I did 5-6 years ago looking at, in part, the indemnity provisions of third-party contracts with a publicly traded company. And in interviewing one of the third parties, they say, well, we're an LLC. We distribute all of our capital assets at year end to make sure our net worth balance is almost zero. And I said, well, how do you intend to fulfill the indemnity provision if it's called upon? And they're like, well, we're an LLC, we'll probably just fold. So that would leave us in this room holding the bag with the idea of, oh, I had this bulletproof indemnity provision that wasn't there. It is a horror story. That's probably not true of most of our partners. But does your indemnity program include, I do need to know what your net worth is. I do need to know what your insurance policy is. I do need to know how you're going to pay this indemnity if we need it, and how often are you checking on that and reviewing it? It's not just, I have it, I bought that contract, this is a contract that auto-renews every year. I don't have to worry about it. It's an ongoing task of sort of making sure it's still there.
Just one other point on the indemnity. So, indemnity clauses are sort of, in my world, my clients say to me, oh, well, that's a lawyer thing, that's a legal thing. I don't really understand what my indemnity provisions mean. And I think one thing in indemnity is general indemnity will indemnify you for lawsuits or claims or actions brought by third parties. So it's sort of one step removed from your contractual relationship with whoever you're contracting with or whoever's contracting with you. So I think when you're looking at your contracts, you want to make sure you understand how disputes get resolved, not only in indemnity with third parties, but between you and the party you're contracting with. So you're looking at limitations on liabilities, you're looking at liability caps. But, we do a lot of contract training because my team reviews a lot of contracts, and we really drill into people. You have to sort of not be afraid of the legal provisions. As good, smart business people, you have to understand all of the provisions in your contract. So if you're going to rely heavily on insurance and indemnity in your compliance programs, I urge everyone to really understand, have a great lawyer who's going to explain them to you, and make sure that you actually understand them.
So, Deb, tell us a little bit about what you've seen as to what happens when things don't go the way they're supposed to.
Yeah, so and a shout out to Rob for some of the graphics on these slides, right? So if you think compliance is expensive, try non-compliance. So the risks of not being compliant, right? So one might say, one of the things we hear from compliance is, oh, I don't have resources, I don't have money, like that's not something we can focus on. And we'll talk a little bit about that later, what happens, how do you set up a program with the resources and funds available to you. But loss of goodwill, loss of your brand reputation, regulators showing up and sort of asking you, where's your compliance program? violating laws that people are looking at you, coming to look at you for liability. So not having a compliance program, the risk of non-compliance is really very, very large in many organizations. And not just, as Terry will tell you in a minute, not just large organizations, right? This applies to everybody. And so while we're here sort of sounding alarmist, our goal is really to explain to you how it's not alarmist and it's really something that can drive your organizations in a very positive way. So I think we're gonna turn now to sort of talking about, well, who are these regulators in your space and what are they looking at? How many people in the audience have ever had to respond to an FTC subpoena or a state attorney general subpoena? Yeah, Christine. Anybody else? Okay, so if you've had to do this, you know that these are time-consuming, they are very expensive, and the regulators have a lot of leeway as to what they can make you do and not make you do. So the FTC is one of the large regulators, Federal Trade Commission, that comes into the marketing space. So we're now going to get our sort of legal lesson for the day.
Yeah, and you won't be surprised to hear this, but under this administration, all of the federal regulators are much more aggressive. And the FTC is no different. And a couple of things, that have happened. They just very, very recently confirmed the 5th commissioner, which previously they had a 2-2 split in the FTC between the Democrats and the Republicans. They no longer have that split, so a lot of the enforcement actions that they wanted to move forward on, they are going to move forward on now. But when I say they are more aggressive, what do I mean by that? Having represented a lot of companies responding to FTC investigations or DOJ investigations, it starts with a civil investigative demand, which is basically a letter that the government sends to the company that says, give me all of these documents and answer all of these questions. And in representing companies, the first thing that we try to do is narrow the scope of that request and narrow the scope of the information that we want to provide, and also provide it in a way that well represents the company and well represents the company's interests. And very often, when you get the SID, it says, provide this mountain of data in 30 days. So we will very often say we need more time, we can't provide all of this information for any number of reasons. What we are seeing with the federal regulators now is the willingness to give those extensions of time are less. The willingness to narrow the scope of the information that they're provided is a lot less. And they're trying to move the cases up to the commission and the FTC to get the authorization to file suits much more quickly, where in the past they had not done that. Deb mentioned, does these federal regulators only go after the big companies? The answer to that is absolutely not. And you can look at the couple of cases that I've put up there. I just went on the FTC's website and took their top 3 press releases, and they're all relatively small companies that they sought enforcement actions at just very, very recently. And you can see that the dollars that they are asking for some of these companies are very, very real. What the FTC does with some of these companies, like the credit game, they move to have them stop their business entirely and got an injunction that the court granted and foreclosed them from continuing their business. For some of these other folks who can't pay these large fines, they say, don't worry about it. You don't have to pay it. You just can't practice in this space ever again. So very real and very serious. You may have, go ahead.
I was going to say, so on the slide you have these, 7-figure settlements in all of these actions. Could you talk a little bit about the recent Supreme Court case that basically told the FTC that they don't have the authority anymore to try and go out and get restitution from companies? That sort of had a lot of buzz and people saying, oh, I don't have to worry about the FTC anymore because they're not allowed to get restitution from me. Can you sort of explain a little bit on that one?
Sure. So the Supreme Court ruled that under Section 5 of the FTC Act, which was their primary act under which they sought enforcement actions, did not allow them to collect restitution. So for years and years and years, the FTC has been asserting enforcement actions against companies and saying, you must return to us as restitution to the consumers that you harmed. The Supreme Court said they never had the authority to do that in the first place. So did the FTC close its doors and close it shop? They did not. They are still there. They are still very active. They've just shifted their attention to other legal vehicles that they can use, like the telemarketing sales rule, which they're seeking to expand and change the rules on through negotiated rulemaking. They've also, and have done this for a long time, but now they are partnering much more closely with the state attorney generals and relying on state consumer fraud protection statutes. The date I have up there is a letter that a number of state attorney generals wrote to the FTC vowing their cooperation with the FTC to continue their consumer protection enforcement actions. So, I'm sorry.
Yeah, I was just going to say, and that's a really significant development because for many years, the state attorney generals have sort of tried to get out in front of or run parallel tracks to federal regulators. And I think, the state attorney generals in general are probably fairly happy that the FTC sort of lost some of this enforcement authority because it gives them sort of more runway with their investigations. And there have been comments from the FTC that they are actively going to now participate and partner with the state attorney generals. And my guess is in a way that they hadn't before. And having participated in, defended in, and negotiated a settlement in a multi-state attorney general action in my prior life, again, expensive, time-consuming, and these regulatory investigations. Another thing to think about as employees is they take you away from your day-to-day business of what you do. One of the best pieces of advice I got when I went in-house for my first in-house legal job was to build very, very strong relationships with all of the employees, because every time I have to ask them to do something for the legal department, I am taking them away from what they do on their day-to-day basis. So they were the people that had to become my friends, and if I showed up in their doorway and said, I'm the lawyer here, you have to do this for me, I probably wasn't going to get a whole heck of a lot of cooperation. But these investigations take up a lot of time from your business.
Yeah, and I can tell you, having prepped more than one executive, they really don't like going down to DC to sit in front of a regulator and get questioned. It's just not something that they enjoy doing, and I certainly don't blame them at all.
Oh, and one other point on the restitution is, I think last week actually, there was legislation introduced into Congress to basically overrule the Supreme Court decision. There seems to be a lot of that going on lately. But yeah, so there's legislation floating around in there now to give the FTC the authority that the Supreme Court said it never had. Okay. So I know Rob and maybe Matt said we're not going to talk about the Telephone Consumer Protection Act, but it would be very, very hard to go to a conference that involves lead gen that doesn't at least touch on the TCPA. So we're going to spend a couple of minutes talking about that. So what's going on there? Like another Supreme Court action about a year ago, the Supreme Court came out and, in the long-awaited decision about what is an ATDS. Before the Supreme Court case, it was, I don't have it up here, but it was my smartphone. And then it's nothing. So can you kind of bring us up to speed as to what is an ATDS these days? And do we have to worry about them?
Yeah, so under the TCPA, an automatic telephone dialing system must include the ability to randomly generate sequential numbers, 001, 002, 003. How many of your dialing systems have the ability to do that? My guess is probably very few or none. The Supreme Court ruled that just merely dialing from a marketing list is not random generation of sequential numbers, and therefore, the vast majority of dialing systems that exist in today's marketing platforms probably don't qualify as an automatic telephone dialing system, and thus are outside the purview of the federal TCPA. So what happened because of that? There was a dip in the filing of TCPA class actions across the country without question. But I think you started off with a mountain of litigation, and you've sort of maybe knocked off the top. There's still a lot of TCPA litigation that's going on. I literally see a new TCPA class action lawsuit filed every day. So what are they filing on? They've shifted to the other provisions on the TCPA, such as do not call, artificial or pre-recorded voices, and are relying on those sorts of provisions to bring claims forward. And they've also shifted to relying on state statutes. I'm sure you're all well aware of Florida's TCPA statute that has got a lot of attention, and there's a lot of new filings. I just saw some data recently that 90% of new state TCPA claims are being filed in Florida under the new statute. And for those states who are seeing that, I would not be surprised to see state legislation to broaden their scope and broaden their attention on that as well.
So those of us that know you in the room know that you are not a shameless self-promoter. And so I'm going to sort of promote for you. And you recently had a nice win in the area where these cases seem to be going away from the standard TCPA cases. So why don't you give us sort of a little download on where that win was?
So I had a client who was, a lawsuit was filed against them, a nationwide class action by, a serial plaintiff, someone who has filed many, many TCPA class actions. It's his side business of earning money. And we decided to defend the case on two fronts. One, the client had expressed written consent. The serial plaintiff, of course, denied it. That wasn't me. I didn't put my name and information on your website. I don't know who did. I don't know how you got it. We said that wasn't a believable story, in part because he spent 30 minutes on the phone with the consumer rep answering all sorts of very detailed questions, so it just didn't align. But I said, to this particular client, had a very strong compliance function and had a great compliance policies and training and all of the data points. And I said, you know what? Let's tell the court that. Let's line up your compliance function against what is known as the safe harbor in the TCPA, and tell the judge that you have complied with this safe harbor because of your compliance function. You have a written policy, you have training, you maintain an internal list, and you routinely work on it. I said, then let's tell the court that because of your compliance function, if this one phone call was made in error, you should not be held liable for it. And so in federal court, when you file motions like this, it first goes to the magistrate judge. The magistrate judge read our brief, read the plaintiff's opposition, and said, you know what? The defense is right here. First, I think that the client did consent, or the plaintiff did consent. But more importantly, this company's got a great compliance procedure, and they're entitled to protection under the safe harbor. The plaintiff objected, so then it goes to the district court judge. The district court judge reviewed it and said the same thing. And so at the end of the day, the case got dismissed with prejudice. But then we had two federal judges who said for this particular client, they have a procedure in place that complies with the Telephone Consumer Protection Act. What a great announcement. And so since that win, how many times has the company been sued for under the TCPA? Not once. Not once. I got hired by the company to handle all of their TCPA litigation because they thought that there was going to be a big uptick in the litigation because the company was growing, they were dialing more, they were buying more leads. And this case came along and I said, let's highlight your compliance function and see what we can do with it. So I love that story because I think it fits in perfect with what we're trying to tell you guys here today.
Yes, and I can say from working with you for many years, you're very good at that, making a problem go away. That's good for the company, but bad for your law practice, so that works. Before we move on, I'm just going to go off script for 1 second, because as I'm sitting here thinking, being back in this room, was here in 2019, have spent a lot of time speaking at Dranaya events, and as we talk about the TCPA, I first met Eli and Lauren in probably 2013 when you were first launching Lead ID, and we were at Career Education Corporation, where I was the head of litigation and the chief compliance officer. We were one of the first adopters of the product, and again, another great example of how compliance can drive your business. Having to sort of convince our marketing team that from the legal standpoint, this was a great insurance policy. This was a great way to manage plaintiffs' expectations, a great way to show your compliance. And, I'm no longer there, but I know they're still using it, and just a great example of sort of how compliance can be, how you can use compliance solutions to sort of drive positive things. So while you were talking, I was just thinking about sitting in this room, 4 years ago, whenever that was. So just a little bit off script there.
Yeah, I've probably have defended 100 lawsuits with the TCPA Guardian, and I love it. I absolutely love it.
I remember, Eli, our conversations trying to explain to you guys how it had to be admissible in evidence and how it was really, really great, but we had to teach you how to actually get it into court.
Moving on.
Oh, you do you do remember that. That is true, you do remember that. Well, it's been a long-standing relationship since then. Okay, so Christine, thank you for sort of highlighting this topic and spoke a lot about it. But data privacy, I mean, I would echo what you said in your session. This is just really the next, it's been the frontier, but it is now sort of the be-all and end-all, I think, that we got to be thinking about as we move into sort of the next kind of wave and stage of compliance. So, and I know you talked a little bit about the state laws that are out there, and so talk a little bit about where do we stand in data privacy, and why should we be worried about it?
Yeah, Christine and John, thanks for your comments in the last panel on privacy. We agree with you wholeheartedly that it is at the top of the sort of the compliance list of things to be thinking about. It is certainly at the top of the legislator's mind, and it's the top of the plaintiff's bar as well. And John, I think you hit the nail right on the head. What is driving it is the data breaches and the ransomware. And I have, my law firm's got offices across the country, and we have a team that does cybersecurity. And like everybody else, we have to go out and market ourselves. We have to find our business. Their marketing job is to answer the phone because they are being called constantly with proactive and reactive when the breaches happen. But it is happening a lot every day. And in response to that, you can see the states are starting to enact these various privacy laws. They're all a little bit different. They all have a little bit different coverage. They all have a little bit different privacy right of actions, or private right of actions, which means that someone can sue if you violate the act, okay? So California's was first, and theirs went into effect in January 1 of 20. And the class action lawsuits in California started coming immediately. In 21, the number of lawsuits filed almost doubled under that particular statute. And they almost all were driven or arose following a publicly disclosed data breach at the company. One of the things that Deb and I noticed about the stats and the data on those lawsuits is that they're settling relatively quickly for very large class actions. And they're settling all for 7 figures and up. And, why is that?
Yeah, so I think part of that is because they're very, very expensive to defend, and sort of because there's no federal law, a lot of this is coming out of sort of, consumer protection, FTC, being transparent and careful with the data that's entrusted to you. And I was sort of taken aback by the report we were looking at because you had all of these actions that were being filed and settling within, 6 to 9 months, which in the class action world, that is really unheard of. Usually they get filed, you move to dismiss, you end up losing, then you move to class certification. Hopefully you get past getting a class certified. But the fact that they're settling so quickly tells me that they're too expensive to defend, and the discovery that would likely need to be done, I think many organizations are really just, kind of behind the curve on putting in a privacy management program, number one. And number two, I think there's a lot of confusion between data privacy management is something different than cybersecurity. And so I think, that's really kind of what's driving a lot of the class actions in data breaches and the time to settlement.
Yeah, and I agree with that. And I think the other thing that's driving it is those statutes are strict liability statutes. You can't say, we really tried hard not to get a data breach. The breach happened, your customer's data got in the hands of the bad guys, you're liable. That's a very, very difficult case to defend. And back to the topic of insurance, insurance policies for cybersecurity are evolving daily. And so, the prices are going up. There's caps on the coverage. What they'll do for ransomware is changing. It's a really, really challenging space. The good news, if there is any good news here, is companies have time to look at these new acts, look at these statutes, and figure out what's required of them. And as you can see on there, those dates that we have under the state laws are the dates that they go into effect. So there is a little bit of time for many of these. California's amendment goes into effect January 1 of 23, which will be here before we know it. But for some of these, they have until July and even until December of 23 before they're in effect. But my guess is by the time that comes, a whole bunch more states will have joined and have asserted their own statutes.
Or we may have a federal privacy law. Going back to our discussion a little bit earlier on, I manage my compliance through insurance. To Terry's point, cyber right now is if you're involved in your company's insurance program, and we just went through our renewal in April, and the premiums are skyrocketing again. There are cyber insurers are leaving the market. They don't want to insure anymore. The sublimits on your ransomware versus your total limits are going down. It's really just kind of not a great environment out there. And for underwriting on a new policy, you're going to have to demonstrate some pretty intense controls to actually even get insurance. So again, if you're relying on insurance, these are things you should be kind of focusing on for your cyber program.
So in our view, obviously, compliance can help mitigate these risks that we've been talking about. So Deb, why don't you tell us what makes an effective compliance program?
Okay, this is where I get to quote unquote geek out, because this is sort of what I spend a lot of time thinking about. So if you have a compliance program in your organization, it is likely that you follow this slide, which are what is affectionately referred to as the 7 elements of an effective compliance program. If you do not have a compliance program and it seems overwhelming, I don't know how to build a compliance program, where am I supposed to start? That's the slide, the 7 elements of an effective compliance program. And these were developed on basically through the federal sentencing guidelines is where they sort of come from. And if anybody is affiliated or sort of aware of the Society for Corporate Compliance and Ethics, the SCCE, this is sort of their model rubric as well. And I think in February of 2017, and then again in 2019, and again in 2020, the Department of Justice has sort of released varying, guidelines and papers about what an effective compliance program should look like. So there are incredible amounts of resources out there to help you figure out how to build a compliance program. But they generally start with these elements. First, they start with written policies, right? So the bedrock and foundation of any good compliance program are your written policies. Policy 1 is your code of conduct, right? So every organization should have a code of conduct which tells people how to behave, what's ethical, what your expectations are, highlight most of your policies. And then your second, if you're doing it my way, your second policy should be what I call your policy on policies, which tells people, hey, here's how you write a policy in our organization. And then you kind of build from there. Secondly, you need to have buy-in for your program. You need to sort of get buy-in, and sort of where does that come from? And I think, most people will say, it comes from tone at the top. You need your senior leadership to buy into your program, which you do, but you need everybody. Building a compliance program is sort of everybody's responsibility. Third, you want to build out your policies. You want to train people and educate them. You want to pressure test your program. You want to do monitoring and auditing, and you want to make sure that you have a really robust way for people to report any possible and potential problems in your organization. And how many people here have third-party hotlines, ethics hotlines that people can call and report to? Okay, great way. So a lot of organizations have them, but people in the organization don't understand them. We did when I first came on board in my new organization, we did a survey to try to figure out, nobody ever called the hotline. We never got any complaints. And I assured my boss that one reason was likely we were very compliant and we had nothing wrong going on, but there were probably other reasons too. And so, for example, people said, well, I don't know who answers the phone. It's probably somebody in the HR team or my manager. If I file a complaint with my hotline, it goes to my manager. So educating people, if you have a third-party hotline, it is nobody in your organization that is taking that complaint. So having a robust way for people to report. When you get reports, investigate them and figure out whether there's any validity to these complaints. Are they substantiated or not? And if they are, do something about them and do something evenly and consistently across your organization. Another thing people said in the survey, well, I don't know, I'm not going to report because nothing's going to be done anyway. Or if I report about somebody, very senior in the organization, you're going to treat them differently than you're going to treat somebody sort of, in lower levels of management. And these responses are not unique to my organization. I mean, if you read any sort of, studies or benchmarking about compliance hotlines, you will see these consistently. So those are really kind of the main elements for how you would build a compliance program. And there's lots of great resources out there. And I'm happy to give my contact information. Anybody who's interested in building a compliance program, I am happy to help.
Yeah, I think those Speak Up programs are incredibly important to a compliant, ethical company. It allows the company to get visibility into areas of the business where they may not be paying attention to, where a problem may arise. And I couldn't stress more if you have those programs, pay attention to them and take action on them. I can't tell you how many times I've been asked to conduct an internal investigation in response to one of these and say, well, how long has this been going on? It's been going on for years. And go back and find, well, somebody raised their hand 3 years ago, but we didn't really think it was serious at the time, so we didn't do anything. So now the company's exposure and liability is threefold. I used to work in-house. I was head of litigation at a publicly traded company, and having been in-house, I'm a firm believer that the compliance department, that the legal department should be partners with the business. The analogies of you go to compliance, they're going to say, no, you're not allowed to do it. Okay, we get it. But if your compliance function is operating appropriately, it's like the business wants to achieve its objectives. The compliance department should help them get there in a way that won't get them in trouble. That's what their responsibility is. The conversation doesn't end at, no, you can't do that. That's the beginning of the conversation. Okay, how can I get here? Because that's what we want to do. And how can I get there in a way that some regulator or plaintiff's attorney is not going to pick my pocket on the back end? And I think that bringing compliance into a conversation of business initiatives on the front end is probably the way you get the most effect and bang for your buck out of that compliance function.
And I guess for any of you CEOs out there or senior leadership who listen to this conversation about the hotline and say, oh gosh, I don't want to create a whole army of reporters. I don't want to go publicize my hotline because then everybody is going to start complaining about every sort of little complaint in the organization. Will it increase, reporting to the hotline? It may not. But at the end of the day, I think one of the takeaways from this session is that you're better off knowing than not knowing. Because if you know, you can do something about it. And to Terry's point, you don't want to know that it had been going on for years and people were either afraid to report or they didn't want to talk about it. And the other one is, oh, well, I don't want to get reporters because then all the lawyers are going to show up and that's going to necessarily be a bad thing. And I have often found, and recently in the last 6 months, I did an internal investigation where all of the people that we interviewed said the same thing. We're so glad you're here. We have something. This was an HR issue, so not anything about unethical or untoward conduct. But basically, they said we really needed someone to talk to, and we're so glad that you're here. And it wasn't, oh, I have to talk to the lawyer, or oh, I have to sort of rat on my co-employee. The people said, we really wanted someone to talk to, and thank you for showing up. So there really are positives to kind of focusing on these things.
And a lot of times the conduct at issue may not be that the business unit or the individual is intentionally engaging in wrongdoing. They may just be missing the mark. Oh, I didn't realize I shouldn't be doing that. And that sort of corrective behavior is absolutely what you want to get from your compliance function.
And I guess just lastly, sometimes you'll do an investigation and you'll find that whatever the complaint is in compliance language is not substantiated. So you don't find that it's true or that there was anything wrong, but you might find what I always refer to as areas of opportunity. So you might find that a policy just isn't working right. Whatever the complaint wasn't substantiated, but I talked to all these people and this policy is something we could improve upon, and I figured that out. So that's really the silver lining of having to go out there and do the investigation, that you actually have the opportunity to improve on something.
All right, so there were a small number of people in the audience who did not raise their hand and may not have a compliance department or compliance function. So Deb, for those people, if they were interested in getting one off the ground, what should they do?
Yeah, so again, going back to the definition of compliance, right? Compliance is following the law. So I would say first and foremost, this may sound like common sense, but figure out what laws, what regulations, what rules, what applies to you, and sort of map that out. So, if in your marketing, right, and we'll talk a little bit about this at the end, truth in advertising, substantiation of claims, you have to comply with various FTC rules. If you're dialing and making calls, you have the TCPA, you have the telemarketing sales rules. So figure out what are the rules and laws that you should be complying with. And that's not to say you're not complying with them, but put them all down and figure them out. And then I think the second thing I would say, if you don't have a compliance function, goes to what Terry was talking about before. Set up a committee. Get a group of stakeholders together. Get buy-in from the right people. So if you have an in-house legal team, it shouldn't be your lawyer saying, I'm designing a compliance program, I'm going to roll it out next week, and you're all going to follow it. Put people in a room that really have a stake in what happens if you're A, not complying with your laws, or B, aren't really aware of what they should be complying with. So I would say that's probably like the first two steps. So once you've figured out what your rules and regulations are, and you've got the people in a room, and you've got buy-in to do this, then pick up the phone and call one of the two of us, and we can help you with the next step. Then pull out my 7-element slide and start from there.
All right. Well, what about those companies that already have an existing compliance function and they want to enhance it and take it to the next level?
Yeah, so if you have it, again, I would sort of sit it down and benchmark it against, these 7 elements. I'd pull out the DOJ's guidelines and read, are you covering all these areas? Now, I don't expect that anybody in this room is ever going to have to sit in front of the Department of Justice, but I will tell you, if you end up sitting in front of the Department of Justice, which I may or may not have done at one point in my career, they're going to ask you, sort of these benchmarks are really the gold standard in compliance, and so you want to be able to say that you have them. And I guess the most important thing I will say to some people that have a compliance program, if you have it and it's in writing, you should be following it. I think you are worse to have, and I see Christine shaking her head, you are better off having no compliance program at all that is in writing than having one in writing that you do not follow. So if you have one, dust it off, make sure you're following it, and then go out and another thing you should do is audit and monitor. So for example, I'll give you an example. When I was in my publicly traded life, we spent, well, it probably took us 1.5 years to get through the whole program. But we started doing what I refer to as CRAs, compliance risk assessments. And we went business unit by business unit, and we interviewed people. We asked them 4 questions. What are the risks that are attended to your business? How do you mitigate against them? Are your mitigation efforts working? And do you see any areas of opportunity? Sound like really 4 very straightforward questions. and we asked them to think about it before they came to the interview. And it was amazing to me how many people didn't say, what a pain in the neck, I don't have time for this, I would rather be doing anything. They said, and I quote, thank you. Because they really had to sit down and say, well, what are the risks? What keeps me up at night? And how am I trying to mitigate against it? We developed sort of a spreadsheet from those interviews, and we had them certify and sign off on them. And every year, well, not me anymore because I'm not there anymore, but my chief compliance officer now pulls it out, and they go back and they say, okay, these were the risks you told us about a year ago. Are these still your risks? So if you have a compliance program, I would sort of recommend doing that. And my last point is, a true compliance team doesn't do the work of complying with the laws. That really falls on the business. That falls on the team. So I'm in the higher ed space, right? So the team in my organization that dispenses Title IV student loans, it is their job to make sure they are in compliance with all of the Title IV regulations. We have marketing guidelines that we recently revised and redrafted. It is my marketing team's job to make sure that the people that they engage with and the content we create follows our marketing guidelines. So that's another thing. I think people think, oh, well, the compliance team is supposed to be doing that. The compliance team is supposed to be checking and making sure that those things are actually getting done. Similar to internal audit, a little bit differently. But so those would be my advice to people that have a compliance program, and what do you want to do next?
As I'm sitting here thinking about this and the resources that go into it, and I'm always, sensitive to that because that's an issue for a lot of companies about, time and resources. I can think of two examples that were mentioned today during this program where work is already being done that could be leveraged to be on the compliance side. So somebody mentioned secret shopping. They do the secret shopping to figure out what the consumer experience is, to drive their objectives to get where they go. But that same data can be used to, as a compliance tool to ensure that no laws or no regulations were broken. The other one is obviously the Guardian, which has multiple uses and multiple tools for it. One, I use it as a defense mechanism, but it's a great marketing tool because there's a lot of data that can be pulled out of it by looking at the data that you're getting and collecting along the way. Is my consent good? Is the font right? Is it an active consent? I mean, there's a lot of information that is being collected and used that has multiple uses that can be leveraged by the compliance team.
I'd give one more, call monitoring, right? So if you're using phone calls, if you're a call center, there's a whole bunch of quality assurance people that are listening to calls to determine tone of voice, cadence, effectiveness of the interaction with the customer. Those same calls can be monitored for various compliance things. And, there are a lot of great tools out there to basically, sort of pull out keywords or be looking for compliance things. So you have these things at your disposal, you just may not be using them in that way today.
All right, Deb, I'm going to leave this last slide to you. I got two questions, and one is, what are the best practices that you want to leave this audience thinking about?
Sure, so I think we've sort of given you great ideas on how to either build a compliance program, how to enhance your compliance program, but I think as we think about talking to an audience of marketers, I wanted to sort of talk a little bit more broadly about what should you be thinking about in best practices in compliance generally. And I would break them down into sort of, three things, right? Content, continuing education, and thinking about what you're doing with your, with your insurance carriers. So content, is what you're saying true? When I used to walk around on my old job and I used to say just two questions. Is it true and can you prove it? That's what, anytime someone came to me, I would say, is it true and can you prove it? And when I left, my compliance team gave me these painted wood blocks, and it just says, one says, is it true? And the other one says, can you prove it? And they sit on my desk today. So basically, if you need disclosures, if you have to disclose information on your websites, are your disclosures clear and conspicuous, right? Are the things that you're supposed to say in the same font as everything else that you have? Are you not burying them at the bottom? Does it not take 9 clicks to get to that content? So thinking about that. Also, if you're producing sponsored content, right, are you disclosing that your content is sponsored and that these are actually advertisements and not newspaper articles? And we got off the FTC before I got to ask you one of the questions I wanted to ask you, which is, hey, I can't afford you, I can't hire you to come teach me about the FTC. Where can I find resources? Where can I learn about these things that I'm now talking about with respect to content marketing?
Yeah, if you guys have ever been on the FTC's webpage, there is an incredible amount of useful information that they put out on how big and small companies can comply with their regulations. It's really amazing how much information you can get right off of their webpage. And if you haven't visited it, you should, because there is great content.
Second?
Yeah, my second question and the last question.
No, I meant my second thing.
Sorry.
So, that's
Oops.
okay. So contracting, right? So the partners that you're contracting with. This is another big area where you can manage compliance without really having to do anything expensive or anything really earth-shattering. Make sure that partners that you're contracting with, if they're putting out messages on your behalf, if you have compliance guidelines, media guidelines, send them to them. Make sure that they're using them and check in on it. Let them know. And then the last point there, which we didn't really talk about, which we wanted to, is risk tolerance, right? Every organization has a different risk tolerance. I always liked the sort of moniker of you can be risk averse, risk aware, or risk unprepared. And so if you're risk averse and you want to basically manage every risk that comes your way, think about that when you're entering into sort of contracts with partners. I like to describe our organization as risk aware. We understand what our risks are. We try to manage most of them, but we understand that we can't mitigate against all risk. Or you're risk unprepared, which is you don't think about risk, you don't pay attention to it, you cross your fingers and that hope that nothing bad happens. So think about what your risk tolerance is as you think about contracting.
And to achieve your business objectives, you probably don't want to be risk adverse.
No.
There's probably a very fair common ground on that risk continuum. I'm hoping that somebody is going to take away from this presentation that compliance is important. And if they want to take that message back to their company, what can you tell them about how compliance can help business achieve its objectives, which was the purpose of this panel?
Sure. So I think I hear this all the time in my legal role and in my compliance role, is I cannot always quantify for you what I do. I don't get credit for the things that didn't happen because nobody knows that they didn't happen. And I can assure you that I spend a lot of time every day making sure that things that shouldn't happen don't. But I think as people talk to you about compliance and they say, well, I can't quantify that. What would be my ROI if I invested X amount of money? I would like to think that, all of the concepts that we shared today can give you sort of ammunition to say, hey, these things are important. Privacy legislation's here and more is coming. Wow, I can't insure every risk I have. And oh boy, those indemnity provisions, people just told me to say, well, we have indemnity, but you know what? I'm not sure we really all know what it means. So I think, compliance should be the necessary good and not the necessary evil. And I hope that that's what sort of we've been able to impart to all of you today.
So that's all we have. We would be happy to take any questions that anybody has.